I had received several requests to talk about the aspects of PCT and Paris Convention related provisions in the Patents Act. And so today I'll be taking up that particular topic so as to help you prepare for the patent agent exam. I'll try and explain what are the different provisions in a very concise manner so as to help you answer the questions related to PCT as well as Paris Convention. So chapter 22 of the Patents Act deals with international arrangements, and the relevant provisions are section 133 till section 139. So before we go into the international arrangements, let us see what does it relate to. So there are few international treaties of which India is a signatory. One of them is the PCT, which is the Patent Cooperation Treaty, and the other one is the Paris Convention. So the Paris Convention came to being in 1883 and the PCT came into being in 1970, and India became a signatory to the Paris Convention in around September 1998, while to PCT it became a signatory in somewhere around December 1998. So let us see what is the basic aim of these international treaties. It enables cooperation between different member states. So like different countries become signatories to these treaties, and then they collaborate with each other so as to enable granting of patents in different countries. So the major aspect of all these treaties is reciprocity. Reciprocity means that one member state offers almost the same rights to the citizens of other member states. So like if India and UK are members of the Paris Convention, so if an Indian citizen files an application for patent in UK, then that particular application would get the same treatment as any UK citizen would get in UK. So this is what is about reciprocity. And the similar happens in India. So if a UK citizen files an Indian application, he would be treated similar to an Indian citizen in terms of the grant of patent and the procedures that are involved, and that is what is called reciprocity. So the member states provide reciprocal behavior to each other or to their citizens. So let us now go through the provisions. Section 133 defines what are convention countries. It relates to any country or any union of countries or maybe an intergovernmental organization like EPO. And these are the signatories to a regional or a bilateral treaty or a convention or arrangement to which India is also a signatory to. So I talked about PCT and Paris Convention. So here we are talking about these bilateral treaties or conventions to which India is also a signatory. So whatever other countries are signatory to these treaties would be treated as convention countries. So it's somewhat like US or UK or even EPO would be considered as a convention country with respect to India, because all of these entities or countries have signed these treaties somewhat like India has done. So section 134 talks about no reciprocity being provided to countries who do not provide us with reciprocity. So if there are some countries who are not providing our citizens any rights to get patents, the government of India can notify that the citizens of that particular country would not get any patent rights or would not get to apply for any patent rights in India. Section 135 talks about convention applications, and this is basically under the Paris Convention. So it says that if a person has filed an application in a convention country, say suppose UK, and then you have the option of filing a convention application in India within a period of 12 months, and based on that you can claim the priority of the UK application that was filed. So if you are filing it within the 12-month period, you can claim the priority of the UK application, and this is called the basic application or the priority application that was filed. You take a priority from that application and file a convention application in India. If you don't file the Indian application within this 12-month period, you lose this priority, and thus this application may become a prior art for your Indian application. The explanation provides that if there are two countries or two different applications in two different countries from which you want to in a way derive your Indian application, the priority date would be counted from the earlier of the applications. Whichever is the earliest date, that would be counted as your priority date. Subsection 2 provides that if there are one or more applications in convention countries and which relate to two or more inventions which are cognate, or maybe one which is modification of the other, and you want to derive a single Indian application out of these two or more applications. So you can file an Indian application taking priority from all these applications, but the basic priority date of this Indian application would be considered as the earliest of the different applications that have been filed in the convention countries. The proviso provides that the applicable fee would be similar to as if you are filing separate applications for each of the cognate applications from which you are deriving the Indian application. So what this means is, if you are taking priority from 3 or 4 applications, you need to pay the additional fee for each of those priorities that you are claiming. So if you would have noticed, if you would have filed Indian patent applications, in the schedule there is provided a fee for each additional priority over a single priority. So you can claim one priority for free, but if you are claiming additional priorities, you need to pay additional fee for each of the priority that you are claiming. Subsection 3 deals with the situation where you filed an Indian application first and then filed a PCT application out of it within 12-month period, and then you filed a national phase application out of the PCT, which is the Indian 2 application. In case of this scenario, the Indian application which was first filed would be treated as the basic application or the priority application for this particular application. And since there are now 2 Indian applications, the provision provides that the request for examination would have to be filed for either of these. So you can either proceed with the examination of this particular application or this particular application. So you would be imagining why such a situation would arise. So maybe you might have filed an Indian application with some content, and then you filed a PCT application with some modifications added to it, maybe which was within the scope of the initial application, but there were more details that were there. And then based on that PCT application, you want to enter India again with the additional details that you have provided. So now you would obviously want to pursue the Indian application, which has the more details, which are more beneficial for you. So now here, what you'll do is you'll pursue this particular Indian application, but your priority date would be counted as that of the first Indian application that was filed. Section 136 deals with what are the provisions related to convention application. So what do you do when you file a convention application in India? It has to be accompanied by a complete specification. That's the basic requirement. Then you specify the priority date and the priority country. So these two details are to be provided so as to claim the priority of the previous or the basic application. And then you have to give a declaration that no application before the priority date application has been filed by the applicant in the convention country. Subsection 2 provides that subject to the provisions of section 10, the complete specification that you file in the convention application in India, which is the Paris Convention application here, which you are claiming in India, would include claims which could also relate to the developments or additions that you have made in respect of the invention that was filed in the convention application. So there could be in respect of the priority application. So whatever you have disclosed in the priority application in the convention country, you can make improvements or developments over and above what was already in there. So provisions of section 10 provide that the complete specification should include claims, and it should define the invention sufficiently and succinctly, and also it should describe the best method of carrying out the invention. So all those parameters are followed here as well. Then subsection 3 provides that no post dating of an application is available for the applications that are filed under the Paris Convention or the convention applications that are filed in India. We had talked about post dating in one of my videos. I'll post the link to that here. The provisions related to post dating are not available for convention applications. Section 137 talks about multiple priorities, and it says that if there are 2 or more applications in respect of a particular invention in one or more convention countries, so you can derive a single application out of it in India. So if there is an application 1 in US and application 2 in Europe, maybe you can derive one particular application and file one application in India. And this Indian application would include the contents of A1 as well as A2. Also, this Indian application would have to be filed within 12 months of the earliest date. So whichever is the earliest priority date, you have to count your 12-month period from that particular date. So subsection 2 provides that the priority date of claim of the complete specification in the Indian application would be when that particular subject matter was first disclosed. So the Indian application may have few claims that relate to A1 and few claims that relate to the invention disclosed in A2. So for the claims that relate to A1, the priority date would be that of A1. And for the claims relating to the invention claimed in A2, the priority date would be that of A2. So here each claim of the Indian application would have different priority dates as per when they were first disclosed. So it is not like all the claims would have the same priority date. Why this is important? Because your subject matter is searched based on your priority date. So each claim would be searched as per its own priority date. So subsection 3 provides that any matter shall be deemed to be disclosed in the priority application only if it was claimed there or disclosed in that in particular application, or in respect of any document that was submitted in the application for protection in the priority application. So if you have filed any document, or maybe that particular subject matter was claimed or disclosed in that priority application, only then it could be said to be disclosed in the priority application, and that's how your claim would get the priority date from the priority application. Coming now to section 138, which provides for supplementary provisions as regards the convention applications. So it provides that the controller may ask for copies of the priority application to be filed, and the applicant would be required to file a duly verified copy of the priority document with the controller whenever the controller asks for it within the prescribed period. So sometimes this objection may be raised in the first examination report, where the controller would ask for a duly verified copy of the priority document to be submitted. So what the applicant has to do is obtain the priority application from the convention country or priority country and submit it to the Indian Patent Office as required by the controller. Subsection 2 provides that if that priority document is in a foreign language, then you need to submit an English translation of the same, and that has to be verified by way of affidavit. So you need to provide a verified English translation of the priority document. So why this is required is because the controller wants to see whether this particular material that you are claiming in your Indian application or the convention application is already claimed in the priority application, so as to assign a priority date to that particular subject matter. Subsection 3 provides that the controller, by way of this priority document that you submit, also verifies that what is the particular priority date given to the application that you filed in the convention country in the first basic application. Subsection 4 deals with PCT applications in particular. So it says that whatever application on whatever documents, title, description, claims, abstract you have filed in the PCT international application, same would be treated as the content for the Indian national phase application that you derive out of the PCT international application. So you have filed a PCT application and you have submitted all these documents there, and when you file a national phase of this particular PCT application in India, so all these would be derived from the PCT application automatically and considered as the Indian application. So in a way, you cannot change the title, description, claim and abstract of the PCT application. You have to just derive it and use it in the Indian application as it is. Subsection 5 provides that for the Indian PCT national phase application, the date of filing would be considered as the international filing date. So whatever is the date of the international PCT application, that would be considered as the national phase date of the Indian application. So your Indian application would be considered to be filed on the same date as the PCT international filing date. Also, subsection 6 provides that if there are any amendments made in respect of the international application, same could be derived in the Indian application that you have filed. So you can request for that and you can imbibe all those amendments that you have made in the international application in the Indian national phase application. So just to revise, there are two types of international applications. One is the Paris Convention. So this is based on the Paris Convention treaty. So you have filed an application somewhere in one of the convention countries, maybe UK, US, and then you derive an Indian application out of it within 12-month period. So the Indian application would be termed as the convention application because this is based on the Paris Convention. And here you will get the priority of the UK application that was first filed. The second is the PCT application. You may have filed any application in a particular country. Let's again take UK. Within 12-month period, you file a PCT international application. This international application is filed within 12-month period of the first basic application. Thereafter, you derive different national phase applications out of the PCT international application. So maybe these national phase applications could be in India, maybe in US, or in Europe, and there are specific timelines within which you can enter the different national phases. So like in India, you enter the national phase within 31 months of the priority date, which is counted from the UK application. Again, in US, you enter within 30 months. This again is counted from the UK application, which is the basic application. One another important point, for the Indian application in the national phase of PCT, the date of filing would be that of the international PCT application. So whatever is the date of the international application, it would be the same for the Indian national phase application. However, in a Paris Convention application, the date of filing of the Indian application would be the actual date on which the Indian application has been filed in India. So this is all about the international arrangements that are there in the Indian Patents Act. In case you have any questions, please drop them in the comments box and I'll be happy to answer those. If you have any comments, please drop them in the comments box as well. Thank you very much for your time.